All rise. The Court of Appeals, Division 1, is now in session.
Thanks. Please be seated. Good morning, everyone. We're here on Bhavnani versus Mukherjee. It's our CV23 0467. As you know, we record and live stream the proceedings, so if when you stand up, you'd give your name and who you're representing before you begin. Each side has 20 minutes, although you're not required to use all of your time. We do require that you keep track of your own time, and if the appellant wants to reserve time for rebuttal, then you let us know, but you keep that yourself. Please keep in mind that we've read all of the briefing, studied the record, and we just got done having a conference on this case. And so with that, you may proceed.
Good morning. May it please the Court.
Good morning.
I'm Roger Cohen on behalf of defendant appellant Deepa Mukherjee. I would like to reserve time for rebuttal. We'll see how it goes. It's an odd case because there are two things going on here that are very disparate in terms of the origins, and yet they all come together at the end. One is that we're dealing with a party who is mentally ill. I mean, there's just no dispute over that. Whatever she did or didn't do, trying to represent herself, Deepa is mentally ill. She couldn't do it. Now, what the consequences of that are, that's something we can talk about. But that's the context. That's how we get here.
Counsel, just so I'm clear from the record, the first time the competency issue was raised was in the motion for new trial, correct?
I believe that is true, Your Honor. I mean, the part of the problem, which we pointed out, is that it took a lot of doing to get to the documents to show that, because the other side had everything sealed in the probate case. So we couldn't just go to the court and pull the records off the file or off the docket.
When you're talking about records, are you talking simply about her court order for treatment records, or is there something else in the probate case? Because I don't remember you arguing that there were problems that somehow she or you were precluded from knowing this about her mental health.
Well, Your Honor, I'm talking specifically about the appendix to the opening brief, where we attach documents that pertain to Deepa's commitment.
Right, her 2009 court order for treatment.
Yes.
Right, okay, that's what I said.
And I believe that we do make the point, I'd have to find it in the briefs, but we do make the point that Mr. Molliver, prior counsel, did not have access to those documents. But on the other hand, Your Honor, you can see it from what was going on in the case.
Right, and that's your argument, and I want you to go down both lanes, which is, one, you seem to say that the court kind of sua sponte should have seen, understood, and then remedied the fact that your client had some sort of mental infirmity. And number two, you also seem to argue that the plaintiff should have seen and known and done something. And I'm wondering about where in the law we find the obligation either at the court to sua sponte do that, or that somehow a plaintiff, knowing that someone has had a court order for treatment more than 10 years prior, somehow has to litigate differently because of that.
It's not just the 10 years prior, Your Honor. It's the way that the case was presented. It's what the plaintiffs say. It was bizarre. The allegations made in the supplemental answer, that they were irrational, they were bizarre, they were just inappropriate. Well, there's something going on there.
Right, and so to the court's obligation, what legal obligation do they have to raise that?
The Cubison case says, Your Honor, that it's they use kind of obsolete language, But the Cubison case says courts have the inherent right and they're duty bound to protect the rights of insane litigants. I'm going to use the word insanity. But that's it in a nutshell, Your Honor. The court knew what was going on, had to see what was going on. And what to do about that, I suppose, is in question. But what really had happened, in fact, is the trial court, instead of saying, well, stop, let's see what's going on. What is the problem with this person? Just threw gasoline on the fire.
And what are we to do with Judge Cooper in particular's findings on that very issue in the minute entry that addresses the motion for new trial, where she makes pretty specific observational findings, at least, about her interactions with your client?
I understand that, Your Honor. And that,
well, what are we supposed to do with those?
Your Honor, we believe that the court, looking at the record as a whole and seeing just the gross injustice here, should send the case back, should make some findings about what the proper rules are, and send it back to the trial court.
But what can you point to in the record that shows us that the judge erred in those findings? Because we're not here to second guess the trial court and reweigh evidence. We're here to look at what the record was and see, where they may have erred.
Well, the trial court said that that Deepa said, I understand what you're saying. Deepa says that what she said was, I hear you, but I don't understand. And what we know from, remember, all this was about was a disclosure statement. And a person of normal competency, normal intelligence, normal ability to read and write English would have the ability to put forth a disclosure statement. I mean, she did, in a way. All of the information, or most of the information that would have gone into a disclosure statement was in the supplemental answer. She has exhibits. She has facts. She has arguments. It was all there. And yet the judge just didn't do anything with that. But it gets worse, Your Honor, and I'm happy to keep talking about this, but there is a second layer in this case, which is that we have a default judgment that's on its face cannot stand. Forgetting about whether the party had mental infirmity, forgetting about that, you can't do what the plaintiffs did in this case. I mean, first of all, they filed a complaint where they alleged specific transactions. I mean, this isn't a situation of, well, there was an accident and there were more than one type of injury or more than one course of treatment. There were completely different transactions. So in the complaint, they cite 3 transactions with Capital Federal Savings, and I apologize, in the opening brief, some of those are misreferred to as Alliance Bank. Then they do talk about an Alliance Bank, $100,000. They talk about Charles Schwab, and then they talk about another Alliance Bank. But when they get to the judgment, when they get to the hearing, all of that stuff's gone. The Charles Schwab, which was $450,000, they don't talk about it at all. And we know why they don't talk about it, because in the complaint, on the face of the complaint, it shows that the personal representative knew about those acts years and years ago, in 2009. And so the statute of limitations has obviously run on those. Then they talk about instead of 3 capital savings account transactions, they only talk about 1, which makes sense because it was 1. The same $100,000 went in and out. So what you end up with then is a judgment that is for a large amount, $60,000, but for different transactions. They've got the capital savings account, capital federal savings for only $100,000, M&I Marshall and Isley Bank, $100,000, Security Bank, $110,000, Alliance Bank, $100,000, and then Alliance Bank for 3 CDs for $450,000. And those are not things that were in the complaint. So the consequence of a default, and this is pretty basic, the consequence of a default is that the well-pleaded allegations of the complaint are deemed to be true. That's all. It doesn't mean that the party that is in default is just abjectly subject to liability for anything that plaintiff wants to pile on with.
And so are you saying that the complaint was insufficient in that it said that there could be other bank accounts discovered? That you're never allowed to say punitive damages to be determined later, or...
It depends, Your Honor.
Okay.
Punitive damages are different. If the facts are alleged in the complaint, then you can draw conclusions from those facts at a hearing. But if the transactions are not alleged in the complaint, you can't. And so, but it gets worse in this case because, in fact, the transactions, when you get to the damage award, virtually all of the transactions were either not alleged, or to the extent that they were alleged, the evidence provided by the plaintiff, the exhibits, plaintiff's own exhibits, show that the personal representative or her predecessor had knowledge more than 2 years prior. They're causing the statute of limitations to have run. The 11/25/2008 Capital Federal Savings transaction, that is shown by Trial Exhibit 8, which is a letter from Capital Federal Savings to Neela Bhavnani.
Is there anything other than your claim of her mental incompetency that excuses her from alleging the affirmative defense of statute of limitations? Is there anything other than her mental infirmity?
Yes, Your Honor. The cases make clear that where even though defendants, even though affirmative defenses should be pled, the court in a default situation is not bound to ignore the facts.
If someone raises them.
Pardon?
If someone raises them.
Well, they're raised. We raise them. We raise them in the...
But it wasn't raised until the motion for new trial.
Correct, Your Honor.
Right. So I'm saying at a
Correct,
default
but that's-
hearing, you're saying the judge, if the court had heard evidence that it found was credible regarding a statute of limitations defense at the damages trial, they certainly, as you said, wouldn't have to look away from that just because someone hadn't alleged it. But there wasn't any evidence in the damages case that there was a statute of limitations.
Of course there was, Your Honor. Trial Exhibit 5 is the letter dated August 21, 2018, which is more than it's actually about 3 years, but it's more than 2 years prior, that says, we have attached the closeout records for any accounts held by Reba Mukherjee since 2008. The court doesn't have to look away from that and pretend it didn't see it. The statute of limitations had run on that. Then you've got the Alliance Bank. And Alliance Bank, those records were sent to Ms. Soderquist's firm in 2012. They had them for 10 years before the hearing. And they're supposed, and now, yeah, you got a pro per defendant who didn't know any better, whether she's mentally ill or not. But that's the sort of thing that a court doing justice can see, and the cases are consistent with that.
So
but
it's the court's responsibility to sua sponte raise a defense for a party?
Your Honor, I've
Based on
certainly
what?
seen it happen in default hearings. I had it happen to me where I was putting on evidence it was in federal court, but still, the court does not have to turn a blind eye and pretend it's not there. Now, but it gets worse, because then you've got a judgment for $450,000 in Alliance Bank CDs that, from everything we've seen, don't exist. They don't exist. There's no evidence. Nobody, it's a lot of money. If someone's seeking judgment for that amount of money, why didn't they introduce them? They didn't, because they don't exist. They have all of the records of Alliance Bank, and there's no CDs in there. And so what's the conclusion? The conclusion isn't, well, then there must be someplace else in Alliance Bank. The conclusion is they're not there. And then it gets worse than that, Your Honor, because what is the evidence that was relied on? The evidence that was relied on was the answer that Deepa filed. And in her answer, there's some ambiguous language about Mom told me to do something with the CDs. But there's also language, and that answer is stricken. So it's either in or
What's the
it's out.
significance of that? So for the purposes of the default, obviously a stricken answer means that the court can rightly enter a default judgment and then have a hearing on damages like they did. But what happens to that answer as far as, are those admissions that she made?
No, Your Honor.
Why not?
Because it's stricken.
Right.
And because she wasn't allowed to explain. And because when she tried to explain, remember, this is not an admission of anything that was alleged in the complaint. This is where all the pieces come together. There was no allegation in the complaint about $450,000 in CDs. But then it gets worse than that, Your Honor. The theory at the hearing, Mr. Fasold, kind of talked around it. But the theory now is that the reason that those transactions, that there's $450,000 worth of damages, is that Deepa got the money after her mother died. That's what the answering brief says. Now, the answer says, I haven't received anything. But let's think about it. What if Deepa did get that money after her mother died, which she didn't? This is not a case of undue influence. This is a case of exploitation, and what we are looking at is a claim for damages. And in order for there to be damages, the adult had to have suffered some injury. And what they're saying is, well, you got $450,000 when your mother died, therefore you're responsible for that $450,000. That's not true, Your Honor. There is no damage on the face of that. And again, the cases say very clearly that in a default situation, if the allegations do not state a cause of action, then you can't enter judgment. Now, it's a little odd here to say they didn't state a cause of action, because that wasn't even talked about in the complaint, which goes back to the original idea that you can't take judgment for transactions that were not alleged in the complaint. I have a little over 2 minutes.
Okay.
I'd like to say that. Thank you, Your Honor.
Sure thing, yep. When you're ready.
May it please the Court, my name is Elise Adams, and I represent appellee Neela Bhavnani in her individual capacity. Also present today on behalf of Ms. Bhavnani is Carol Soderquist, who represents Ms. Bhavnani in her capacity as personal representative. Ms. Bhavnani and her husband Pritam are here today. Just for ease of reference and clarity, I'll be referring to the parties by their first names. Is there a specific area that the court would like me to focus on, or specific questions that I can answer before I get started?
I mean, we could start with that. What we were talking to Mr. Cohn about at the end was what happens to an answer when it is stricken from the record for the purposes of the appellant being able to refute the claims, the underlying claims, but what happens to the statements? Is there any case out there that says that your statements in answers can be concessions, can be statements that can be used in another way?
Sure. I think you nailed it on the head. There isn't an Arizona case or statute or rule that precludes a trial court from considering a defendant's prior under oath statements when determining appropriate damages.
When counsel wasn't under oath?
It's her own statement. And so I guess it wouldn't be under oath of penalty of perjury, but it was a prior statement. And so to the extent that it could be used to show that it's a statement that she has made, she is admitting to these allegations. So it might have been struck as a responsive pleading, but it wasn't struck as one of her own prior statements. And so it would have been the same of had she gone in and said it to a friend, and then the friend came in and testified. It's the same kind of distinction there.
Is there any distinction because she actually filed the document with the court?
I think it goes to a duty of candor to the tribunal. I think, and it goes to the credibility in that the trial court, to the extent she were to say it to a friend, the trial court would have made a credibility determination as it related to the friend. Here, we have her own statement in which she has said, I took these CDs. And so I think to the extent she had a reason not to say that, she would have. And to the extent she had a reason to say, oh, I didn't mean that, I meant something else, she had the opportunity to clarify that at the default damages hearing that she was present for, and the trial court observed her behavior and said she was rational and coherent. Did I address that question?
I think I want to spend a little more time on the effect of a pleading being struck from the record. I mean, you know, when it's struck, and as you mentioned, there's no Arizona case law on this. When it's struck, it's not part of the record.
At that point, but it could be reintroduced into the record. And so just because it's struck doesn't mean it no longer exists. It's still a piece of paper.
So your position is that it's no longer part of the record, but it can be used as a piece of evidence, just like anything else can be introduced as a piece of evidence.
Exactly.
So is it true that it's no longer part of the record when it was filed in the record, or it shouldn't be part of the underlying default determination?
I think when it was struck, it no longer became a part of the record, but again, it could have been reintroduced, which it was during the default damages hearing.
Did your client reintroduce it?
Yes, at that hearing, it was admitted into evidence.
Was there any testimony from the author of the document about the document at the hearing?
She was given the opportunity to make a statement to the court. She had the opportunity to explain that, and she didn't.
Okay, thanks.
So answer it a little different. She had the opportunity to clarify, to say what she meant, and she didn't take that opportunity to do so.
Was she placed under oath before she was offered
I believe she was. From the
statement?
trial transcript, it's not clear, but I believe she was placed under oath.
And what, we've heard a lot about the discrepancy in the allegations in the complaint, the record keeping, and even if we were to consider the answer, that things don't line up, and that at a default, defaulting, we say that you default under the penalty of having the complaint being read as true, but in this case, tell me what your thinking is about saying something so general as to, and any other account we may find at any other time that we may allege, and you could have come in with 300 allegations of financial fraud that she would not have been on notice of could have been part of the judgment against her. So where's the line there between being able to say, yes, we're still investigating, but I don't have to file an amended complaint to add different accounts that I'm finding that I want to include in the complaint?
Sure. So in deciding whether a default judgment differs from the complaint, the necessary inquiry, as I think was alluded to, is determining whether both the complaint and the prayer for relief put the defendant on notice of the penalty she faces should she allow a default judgment to be entered against her. So as permitted under Civil Rule 8, Neela's complaint provided examples of Deepa's exploitative acts and explained that she expected additional discovery to reveal additional money that defendant took from her mother. In the prayer for relief, Neela requested that a judgment be entered against Deepa in an amount to be proven at trial. Deepa's interpretation of Rule 54 that only concrete dollar amounts that are explicitly laid out in the complaint would render the hearing requirement under Rule 55 superfluous.
Well, no, but you still have to be able to prove up
Sure.
the allegations in the complaint, so the hearing wouldn't have no relevance. It has relevance to say you've made these allegations, but you still have to prove them up.
Sure.
And so if she defaulted and said, well, the things that are listed, I'm fine with. I did those things. I don't have a problem if there's a judgment against me, or she's never going to be able to get a judgment at whatever. But that she could be under a damages award that lists so many other things that she didn't know, that's where it's a little bit hazy as to, yes, she had a right to continue to investigate, but did she have a right to update the complaint when she had specific accounts that she later found, or amounts that were different, or banks that were different? Did she have an obligation to amend the complaint to put her on notice?
I think that would have been a great argument to have been made prior to the default hearing. So to the extent she came in and said, I don't have any of this information, that would have been one thing. But this would have been laid out in the initial disclosure statement that Neela put together and provided to Deepa, outlining where those allegations came from and where the dollar amount came from. It also would have been included in the trial exhibits that she received before the evidentiary hearing. So she was on notice that this was coming, that this is what the damages were sought. And it was in some of the earlier pleadings before the evidentiary hearing that also outlined this is what we're going for and this is what is making up the dollar amount that we're seeking. That would have been in the default packet.
Okay, but her line before is really kind of before default, right? Is what she had notice of when she chose, when she was acting in a way that potentially had a sanction of default. I mean, when you say, well, once we got to the damages, we had a big package of all the things she was, well, no, because that's a post-default, telling her post-default all the things that she is to incur if you can prove them up at a damages hearing isn't the notice that I'm talking about.
Well, but it also wouldn't have been post-default. It also would have been included in the initial disclosure
Well, that's what I'm
statement.
asking you.
Sure.
The way you said it there could have been different things.
Yeah.
So, yes, in the discovery and the pre-default statements, you're saying she was on notice about what you were going to be seeking.
Exactly.
Okay.
It was both pre and post-default. This wasn't a secret. This was not something where we were trying to play gotcha with her to say, aha, if the complaint said $850,000 and we're actually going for $853,000, but they're different allegations. No, this was all laid out prior in an initial disclosure statement that was sent over to her and that she was aware of.
Counsel?
Sure.
How do you respond to appellant's counsel's argument that the onus was on the court and or the plaintiff to bring up the statute of limitations issue when it wasn't raised by appellant as an affirmative defense?
I candidly don't really understand that argument. Why would a party need to play both sides of the field? Why would a party be required to do its job as a plaintiff and also do its job as a defendant? To the extent that Deepa wanted to raise that statute of limitations defense, she had numerous opportunities to do so. She could have done so in her answer, didn't do it there. She had the opportunity to do it in her motion for reconsideration, in which she was represented by counsel didn't do it there. So there was times in which that could have been raised. It didn't happen. And so I don't think it's, in terms of a fairness argument, to say it's fair for the plaintiff to anticipate and make every single argument for the other side just because they're a pro per. Because that it would put them at a different standard than if I were litigating against an attorney. I wouldn't do that for an attorney. Why would I do it for a pro per? It doesn't make sense.
Counsel, can you just touch briefly on, there's an allegation that, there was knowledge of her mental illness, and can you just touch on that
Sure.
for us a little bit?
So I think the panel kind of hit the nail on the head in that we are unaware of anything post-2009. There is nothing in the record, nor were we presented with anything to show that Deepa has a current mental illness, deficiency, disorder, anything. Could she have presented that? Sure. There was ample opportunity to do so. It didn't happen. Instead, what they're relying on are things from 14 years ago that could have changed. We don't know. And so to the extent that there is an argument to say that she's incapacitated or mentally ill, which is not a word that is used anymore, but to the extent that it's there, that should have been provided to us in the form of a physician's report, something to give us something to say, okay, we understand, let's move forward with getting a guardian ad litem appointed for her. Let's move forward with getting a guardian appointed for her. But nothing was presented to show she has any sort of mental illness.
But what counsel is arguing is that her presentation in court, her presentation through her pleadings should have been notice enough for the court to have a question. Can you speak to that?
Sure. I disagree. I think Deepa appeared before 4 judicial officers, all of whom interacted with her in real time and none of whom raised concerns. Instead, we have Judge Cooper saying that Deepa was rational, she was coherent, she understood. And so there's nothing in the record to show that the court should have stopped and said, I'm seeing her, she seems fine, but I need to look into this further. I think once the court observed her and was able to say, okay, has the ability to stand trial, that was sufficient.
Thank you. Counsel, I have one more area
Sure.
that I want to talk about, and that's your request for attorney's fees and costs. One of the statutes that you cite is for sanctions, and I'm just wondering if you can visit on that a little bit as to, what your justification for that is and why.
Sure. So a lot of this has come because it has been a change in litigation after the entry of default. And so all of this and all of the attorney's fees that have been incurred are, now that counsel has come in and throwing everything at the wall to see what can stick. And so we had that initially in the motion for reconsideration where they argued certain things. That was ultimately denied. Then we have new counsel come in arguing new things. It's one thing after another after another. It's also the pattern and conduct of her behavior, not only in this civil matter, but in the probate matter. It's gotten to a point where it's to the point that it's expanding these proceedings unnecessarily and incurring additional attorney's fees unnecessarily.
But this is only the
Sure.
civil matter, right?
Yes.
So anything going on in the probate is not something for us to be considering.
Correct. And so really it's just to the extent that this court feels that this appeal, and what it's seen in its review of the record have unnecessarily expanded the proceedings, were not based on law or fact, which I think is pretty apparent when we start to get into the argument that there should be a new standard for someone who is not incapacitated, but is not an attorney. I think those are the types of things where we're getting into the realm of there's no law to support this new standard that's being requested, there's not a good faith basis for the purposes of these appeals, of this appeal.
Thank you.
Can I answer any additional questions? I could talk for another 4 minutes, but I just want to make sure that I've addressed everything with the panel.
Do you want to address specifically about, Mr. Cohn was raising the CD issue and just the, how the court put together what the final judgment was, and whether even in light of the argument that you could have, that it was disclosed pre-default and those kinds of things, but the matching up of the numbers that were found, if there was a right to have that hearing and if everything else went perfectly, matching those things up, is there anything you wanted us to know factually about why Mr. Cohen's assertions earlier were incorrect?
Sure. So the trial court entered a judgment in the amount of $860,000 and change. So that was made up of approximately, we'll call it 5 discrete examples. The first being a $100,000 check issued to DEPA from M&I Marshall Bank. The next was $100,000.
Was that in the complaint specifically, the
No.
M&I Bank?
No.
Okay, and so where would she have noticed that that was something that could have been included in a default judgment? Is there?
The initial disclosure statement, the default packet, trial exhibits.
But not something that ever made its way to the complaint?
Correct.
Okay.
And really, there wouldn't have been an opportunity for us to move forward with an amendment, because at this stage, one, this was never raised, hey, I'm not on notice of this, because from our standpoint, she was, because it was raised in the initial disclosure statement. She's getting these trial exhibits, she's getting these things. And so from our standpoint, we had no reason to amend because our complaint has laid out the 3 criteria for financial exploitation of a vulnerable adult. It's asked that the court issue a judgment and amount to be proven at trial. And it has said additional discovery may find other examples of financial exploitation.
All right, and in the interest of time, what
Sure.
other amounts were not specified in the complaint that you were given a judgment on?
So I don't have a copy of the complaint with me. I just have what the judgment was
Okay.
made off of. So I apologize for that, but it's $100,000 in cashier's checks issued to DEPA from Alliance Bank, $450,000 received from Alliance Bank upon Reba's death, $100,000 in funds withdrawn by DEPA from Capital Federal Savings, and $110,000 in funds with Security Bank that were never disclosed or turned over to the conservator.
And what about because wasn't the over $400,000 the CDs, the at death thing is a little bit confusing as to she didn't have a right to have something given to her upon her mother's death? I mean, how was that proven up to be exploitation when, as Mr. Cohen raised, there wasn't any kind of undue influence alleged? I mean, vulnerable adult, yes, that's alleged, but what about getting post-death amount like that?
Sure. So I think the issue is that financial exploitation of a vulnerable adult requires that a party receive funds that are not for the benefit of the vulnerable adult. And so by having the $450,000 in an account that then Reba didn't have access to, that then is allowing DEPA to pull from those funds, to utilize those funds, not to Reba's benefit, but for her own benefit. And so
But she didn't have control of the funds until Mom died, right?
I would have to,
Well, I mean, isn't that what you're alleging, is that she got something after death?
I would have to go
Okay.
back and look,
Okay,
but I think
I can do that.
I think it would be that either it was a joint account that she had access to, there was something with that account, and it might be explained better in the transcript of the evidentiary hearing,
Okay.
but there's something about that account that prohibited Reba from utilizing the funds for her own benefit, and instead DEPA was the one who was able to use those for her benefit.
Okay, fair enough, thank you.
And I'm out of time. Thank you all.
Thanks.
Thank you, Ernest. Very briefly, first of all, there was one of the things that struck me about that presentation is that Neil is saying, well, how can I be responsible for knowing things that were from 14 to 15 years ago? This entire case involved a lawsuit brought in 2021 for transactions that occurred 14 to 15 years ago. The problem is theirs. They didn't have to wait 14 or 15 years. They chose to wait. They chose to lie in wait and use their greater financial resources to attack Deepa when she had no ability to defend. I want to talk about the very last thing that was said about the $450,000 in CDs. There was no evidence. The court can look at the transcript. There was no evidence that Reba didn't have access. There was no evidence that there was an account. Nobody explained what those accounts were. They're just these, well, there's 3 CDs, and what's really amazing is Deepa has a funny way of talking, but she said plus or minus $150,000. They just assume that means $150,000. And the only other thing I want to say is that it is not true that Deepa was given the opportunity to talk about damages. Remember, there's no way to separate damages from new transactions because we're talking about the amounts of money that were allegedly constitute damages. And Deepa tried to talk. She said, I don't know. I'm sorry, but at page 39 of the transcript, Deepa says, yeah, it's the complaint or whatever. I read this. It said I had stolen. First of all, I did not steal, okay? It said I had stolen $605,000 by mom. Now, it also said that back in 2004, I had a tiny piggy bank collection of 400 and some thousand. So common sense tells me that I didn't steal. And then it goes down, this defeats common sense telling me I stole anything from my mom. And then the court says, ma'am, this is a default hearing. And what this means is with the specific damages have been presented by counsel, do you have any testimony to give me with regard to those damages? If you don't, then I will go ahead and turn the time over to plaintiffs for their closing. So this is the problem, because everything was commingled. There is no distinction between damages and different transactions. To say that Deepa had the opportunity to talk, she did not.
Okay.
Thank you.
Thank you so much. Thank you for your arguments. We'll take the matter under advisement and issue our decision in due course. The court is adjourned.